Masechet Baba Mesia Daf Kof Dalid Nu Mishnah Hamkabel Sadeh Mechavero V'hi Bet HaShelachin O Bet HaIlan Yavash HaMa'ayan V'niksas HaIlan Eno Menakeh Lo Min HaChoro. If a tenant farmer receives a field from his friend that he's going to work on, and he's going to give the landowner a certain amount, and it is an irrigated field or a field with trees. Now, an irrigated field, Bet HaShelachin, is a field that cannot rely on rainfall alone. It needs to be irrigated from some other, from a river or some ditch. And therefore, it comes along, it means it's nearby some kind of water source. So on the one hand, it takes work, extra work, because you can't rely on rainfall. On the other hand, this is a positive thing because obviously there's going to be some source of water, a well nearby to use in order to irrigate it. That's case one. The second case is it's a field that has trees on it, which is also good for the tenant because the tenant doesn't have to do anything to take care of the trees, and yet the tenant, we saw there's some cases where it's included or not included. In a place where it's included, can benefit from a share of the fruit of the trees. So both of these things are for the benefit of the tenant, having that water source there. But let's say they have an agreement and a tenant farmer goes and he's working on it, and the well that he was relying on dries up, or the trees that were there get cut down, and now he cannot benefit from those positive things. So can he go to the owner and say, listen, I need a discount. I can't pay you the $1,000 that I said I'm going to give you because look, there's no water here, the trees aren't here, so this is not fair. The answer is no, he cannot do so because it was not part of the stipulation when they agreed. The owner said, here, I'm going to give you this field, and it happens to be it was an irrigated field or a field with trees on it, but that was not mentioned as part of the deal, and therefore he's still going to have to come up with the same amount that they agreed to. On the other hand, Ima Malo Hakor li Sedeh Bet HaShelachin O Zo O Sedeh Bet HaIlan Ze Yavash HaMa'ayan V'niksas HaIlan Menakeh Lo Mechachoro. If on the other hand the tenant comes and says, I want to be a tenant farmer for this irrigated field or for this field that has trees on it. Remember these words that in the second sefa says zo and ze. In that case, if the spring dries up or the tree gets cut down, then he can ask for a discount and say, listen, I asked for this irrigated field, and that assumes that it's going to be a field that requires irrigation that has a well nearby. I was relying on that well. If it dries up, then that's not part of the deal that I agreed to. So because he specified this particular irrigated field or this field with trees, and he said with trees, that means he only wants to take it if it's with trees, and if the trees get cut down, then he doesn't have to pay as much. Good. Hechi Damed, the Gemara asks, what are the particulars of the case? If what dried up exactly? If it's the big river that feeds all the little rivers, the whole big river dried up, the entire area has no water, then how come in the Resha he cannot discount from what he pays? Because in that case you could say, this is a regional disaster. When there's a disaster that covers a whole region, well then the contract is null and void. The tenant says, listen, there's a whole natural disaster over the whole place. There's no water, and nobody has water, and therefore I don't have to pay you as much. And that would be a valid claim. So Amara Papa de Avash Nahara Zuta da Amar Le. So the Papa explains it's not when the big river dries up, but rather when one of the small rivers that's near this field dries up, and now it's going to be a lot more difficult for the tenant farmer. If as that little river there, he can dig some ditches and direct the water onto the field. So now it'll be more difficult, but the owner can still say, listen, that means you have to get pails and go farther away to some upstream and carry the water. It's more work, but that's the deal. Because that's talking about the Resha, where he just said, I'm going to give you a field, and it happens to be that it was an irrigated field, but the tenant didn't ask specifically for an irrigated field, and therefore he has to uphold his term of the deal, and he can't just say, well, but the water source isn't there. All right, but the owner says you have to bring it from farther away. Amara papa, hane tarte matnita kamaita, mashkachata ben bechach ranuta, ben bekablanuta. Bikan ve'elach dita bekablanuta, leta bechach ranuta, udita bechach ranuta, leta bekablanuta. The papa says that the first two Mishnayot, the first one of the Perek and the one that we just read, the law is true whether it's a chachdanuta, that's a tenant farmer, or a contractor, or in other words, a sharecropper who pays a certain percentage. That's true for the previous Mishnayot. However, going forward, the next Mishnayot, there is a distinction, and if it's true regarding a sharecropper, it's not true for a tenant farmer, and that which is true for a tenant farmer is not true for a contractor, and therefore we have to make a distinction in the laws after this. Now, back to the Mishnah. Im amar lo chakor li sedeh bet hashlachin zeh. In the Sefer, he said, I want this irrigated field. He specified an irrigated field, which assumes it comes along with a water source. Ve'amai, le'maleh shema be'alma amri lach. And now we ask, why does the tenant have a right to pay less? Can't the owner say, no, I was just talking about the irrigated field as a name, as a way of designating it. Right now, let's assume it doesn't matter who proposes the deal, whether it's the tenant farmer that comes and says, I want this irrigated field, or whether it's the owner that comes and says, hey, I'm willing to give you this irrigated field, right, for this amount. Right now, let's say there's no distinction who says it. The point is that since they both agree and one of them mentioned this irrigated field, that means that they want an irrigated field, which we assume comes along with the water source, or a field with trees. Since one of them said a field with trees, so then he has to give them the trees. And if there are no trees, he can pay less. But now we ask why. Maybe they were just calling at the field with trees, just to distinguish it between some other field that didn't have trees. But maybe the tenant didn't mean to say that on condition that it has trees, on condition that it's an irrigated field with water. And after all, we have a bunch of other examples where even though something is called a certain thing, where it's also called that by name, and we're not particular about the details of why it's called that, as follows. Mila Tanya, ha'omer lechavero bet kor afar ani mocher lecha, af al pi she'en bo ela letech higi'o, shelo machar lo ela shema, vehu de mitkere bet kor. We have a braita that says someone tells someone else, I am going to sell you a bet kor of dirt, a field that's the size of a bet kor. Now, even though it actually is only a letech big, which is half as big, still the sale is valid. Why? And the buyer can't say, oh, you told me you're going to give me a bet kod, and now I only got half, which is a letech. He can't claim that because he just called it by a bet kod, because that's how he designates it. Maybe it used to be a bet kod, and then he sold off half of it or something. So he calls it the bet kod. So since that's just the popular name, and then we add, it has to be in fact called bet kod, right? Go ask around, and everybody says, oh yeah, that's the bet cornfield. So if that's called that, even though it's not a proper correct name, so it's called that. It would be kind of like if I sell you the deal casino, and then you say, wait, there's no casino there. Well, yeah, it's just called that, even though there's no casino. Maybe there used to be a casino a long time ago, but since everybody calls it that, so if I sell it to you, even though there's no gambling there, right, that's a valid sale because everybody calls it that, even though the name is not correct, but that's the official name. That's what people call it. Now, karma ani mocher lecha af al pi she'en bo gefanim higi'o shelo machar lo ela shema vehu mitkare karma. If I sell you a vineyard, even though there's no vines on it, it's a valid sale because I just called it a vineyard. If in fact people call it a vineyard, maybe once upon a time it was a vineyard. If that's how I designate it, and I sell it to you, it's a valid sale, even without vines. And the same thing, pardes. Ani mocher lecha af al pi she'en bo rimonim higi'o machar lo ela shema vehu mitkare pardesa. If I say I'm going to sell you an orchard, even though there's no pomegranates there, if that's what people call it, that's the orchard, well, then that's that the sale is valid. So you see, in all these cases, the seller can say, I was just calling it that. I didn't mean that as a description of what I'm actually selling you, and it's valid. So too, we should say the same thing here when the owner says, I am selling you a irrigated field, right? That's just what I call it. I didn't mean that there's also a water source necessarily. I call that land over there the land with trees, because at one time there was trees on it. But I didn't mean that there actually has to be trees. That's just the way that I call it. And lots of people here call it that. Then it should be valid. And in the sefa, the tenant should have to pay the full amount. He can't claim, oh, you said it has trees. Amar Shemuel, we have two answers to this. Shemuel says, La kashya, had amar le machkir lechoker, had amar le chocher le machkir. Amar le machkir lechoker shema be'alma amar le chocher le machkir kepeda. So Shemuel says there actually is a difference between who proposes the deal, who is saying these words. Before we were assuming that there's no difference. Shemuel says that there is. And one is where the owner says it to the tenant, and one's where the tenant says it to the owner. And we explain, if the owner says it to the tenant, then he just means that's how he calls it. And he didn't mean that it has to have a water source there, that it has to have trees there. He says that's the way I call it, but I wasn't dependent on it actually having water and having trees there. In that case, you're right. The owner can say, I was just calling it that. You have to pay me the full amount. Whereas if the tenant is the one that proposes and comes and says, I want the irrigated field, he's saying that because that he wants particularly an irrigated field with water or a field with trees, and therefore he is particular about it. It's that on that condition, and if you don't have that, then he can deduct from them the amount he pays. A second answer, Ravina Amar, Idi v'idi damar le machkir lechoker. Ravina says, no, there's no difference between who says what. Both of them could be that the owner tells the tenant, Umedekamar ze mikelal deka'e begava askinan betashlachin lama le lememar dekamar mele betashlachin kedekayema hashta. No, from the sefa, remember, it says the word ze. I want this irrigated field. If he's saying this, that means they're right there. You're standing inside it or right alongside. They're pointing to it. So he says, I want this one. And therefore, since he says, I want this one, so he has to give it to him as is. Now, if he's saying this one, why does he have to add bet hashlachin? Just say this one. They're pointing to it. So why is he saying, I want this irrigated field? What he means is, I want this irrigated field as it is, with the water source right there as it is right now. And therefore, if the water source dries up, then he says, this is not the deal we made, and that is, he has a legitimate claim not to pay the full amount that they agreed to. Next Mishnah, המקבל שדה מחברו והובירה, שמין אותה כמה ראויה לעשות ונותן לו, שכך כותב לו, אם עוביר ולא העביד, השלם במיטבה. Someone receives a field from someone else as a sharecropper, and instead of working it, he just leaves it fallow. Since he's a sharecropper, he only has to gives a percentage. Unlike a tenant, he has to give a fixed amount. In that case, if the tenant leaves it fallow, tenant's still going to have to pay. But a sharecropper only gives a percentage, and so he just leaves it, doesn't do anything at all. So now the owner loses out a whole season where his field is not being worked, and he's not going to get any money from it. So that's not fair. And therefore, we appraise it and figure how much would this field produce if it were worked properly, and the sharecropper has to pay whatever percent, let's say they said 50-50, he has to pay him 50% of what it should have grown, even though he let it lie fallow. Why does he have to do that? Because this is what it says in a typical sharecropping contract. And even if you don't write this, this is assumed. It says, if I leave it fallow and do not work it, then I will pay from my best quality produce. Have to pay out of pocket from somewhere else, and I'll give you the best quality for not working the land. So that's a guarantee that the owner of the field will know that he will actually work it, and if he doesn't, if he's lazy, then he will get paid anyway. Rabbi Meir haya doresh lashon hekdesh, lashon hedyot. Tetanya, Rabbi Meir omer im ovid vela abid ashalem b'meh taba. Now we're going to learn a very important principle, not so easy to explain, but it's going to come up a lot here. So Rabbi Meir would make a dirasha, he would expound, explicate, even language of regular people that's not holy. So when we say doresh, we think of derasha, the 13 attributes shatorah nidreshet bahen, and right, kal vachomer gezerah shava, that's Bishmael's 13 characteristics of Torah language, that it's written in such a way that you can derive various laws through those 13 principles. And so that's what we call derasha. Now, everyone would agree that the Torah, you can make derashot on the Torah. Here's the question. What about a different a document that's not holy like the Torah? Is the fact that we make a derashot on the Torah a function of its prophetic status, of its kedusha? So the other opinion against this that would say we do not make a derasha on Lashon Hajot would say, yeah, only holy books we make a derasha, otherwise we would not. Rabbi Meir, however, says not so. The reason why we make a derasha is not simply or only a function of it being prophetic, but rather it's a legal text. Anytime you have a legal text, we read legal text differently than we do ordinary texts, because a legal text has to answer all questions about that subject. If you go to a law court and any law system, and you come up with a case of stealing or something, the judge cannot simply say, well, our Constitution here doesn't address this case, I don't know. The judge has to say guilty or innocent. You have to come up with something. And therefore, they're going to have to interpret something in that law book, find a case that's similar in some way, or make a careful reading, a diuk in the language, that this language must mean this and that. Since it doesn't say it, it must mean something else. Compare the wording here and there, and so on. And so legal language has its own system of interpretation. And that's what Rabbi Meir says. So this is going to impact us on two levels in the following. We're going to have a few examples. Number one, it means that even a secular contract is binding. Although, if we just speak in normal language, we're just having conversation. So then I might say something, like, I'll give you $1 million if it rains tomorrow. So I don't really mean that. That's not binding language, because it's not legal language. I'm just saying it. So number one, if it's written in a contract, also, if it's written in the Torah is not only a book of prophecy, it's also a legal text, right? It's a binding legal text that we agreed to in a berit at Matan Torah. And therefore, if it's written in the Torah or in a legal contract, then it's binding. That's number one. Second is the type of interpretation that we apply to it. Doesn't necessarily mean we're going to apply, every gezerah shava and so on. The Torah is special in that way, and there's various ways, Rabbi Akiva, Rabbi Ishmael, and different systems of learning things from the Torah. But on some level, we are going to apply interpretation on a legal text that we would not normally apply if it was a non-legal text. So that's what it means, Doresh Lashon Hedyot. Okay, the application here is that, in the Braita Rabbi Meir says, we write in the contract of a sharecropper, if I leave it fallow and do not work it, then I will pay with my best quality produce. And that's not just an exaggeration, like, oh, don't worry, I'll give you $1 million if I don't do my best. This is legal language, and therefore it's absolutely binding, literally. Okay, in this case, you don't have to do much interpretation for it to understand it. Now, Rabbi Yehuda haya doresh lashon hajot. Now we're going to give a whole list of other Tanaim that also abide by this principle, that we interpret a language of non-holy language in a legal way, even to make derashot. Detanya, Rabbi Yehuda omer, Adam מביא קורבן עשיר על אשתו, וכן כל קורבן וקורבן שהיא חייבת, שכך כותב לה, אחריות תהית ליך עלי מן קדמת דנא. Rabbi Yehuda teaches in the Braita that a husband, has to bring a rich man's korban for his wife. There are various korbanot that or sliding scale, ole v'yored. For example, a yoledet, a mother who gives birth to a child, has to bring a korban. If she is rich, she brings an animal. If she's not so rich, she can bring a bird. Now, if, let's say, she has no money of her own, but she's married to a rich guy, so the law is that if the rich guy is rich, then he has to provide for her money to buy an animal, not just a bird. Why? Because for every korban that she is liable to bring, the husband writes in the ketubah the responsibility for any obligations you have, even obligations from beforehand, from before we were married, I take upon myself. So the husband has to pay for any bills that she is responsible for. And this korban is something that she has to bring. This would exclude a voluntary offering. If she says, I want to bring korban olah, well then, she has to bring whatever she can afford. He doesn't have to do that. But anything she's liable to bring, like korban yoledet, since he's responsible and he's rich, so he has to bring the animal. And so we see here that although the ketubah is Lashon Hejot, this is not a book of, it's not part of Tanakh, even though it's part of a holy ceremony of marriage, but the ketubah itself is simply a legal financial contract. And even so, it's binding. And since he says, I'm responsible, so that takes binding effect, and he has to pay for the best animal. Hillel hazaken haya doresh leshon hejot etanya. Anshe Alexandria hayu mekaddeshin et neshotehen, ubishat kenisatan lechupa ba'in acherim vechotfin otam mehen, ubikshu chamim lasot benehen mamzerin. So Hillel, the elder, also would expound common language, and here he's going to actually have to require a real derasha that's against the simple peshat reading. Here's the story. The people in Alexandria, they would do kiddushin with their wives, and they would do it sometime before the nisuin, maybe some months before. And then, before they would actually do the wedding under the chuppah, other people, these thugs, would come and steal away their wives. And they would just take them and have children with these women who they did kiddushin but not nisuin. The law is that even if it's only kiddushin, if she sleeps with someone else, that's called adultery. If she does it on purpose, capital punishment. If she's forced to, she gets no punishment. But either way, if she has a child with someone else, that child will be a mamzer. And so the rabbi said, this is a very unfortunate situation, but these children are going to be mamzerim. Now, having a mamzer is a very serious problem. You can't undo it. So Hillel HaZaken came to the rescue, and he said, bring me your ketubot, the ketubot that you had written with your original husbands. Let me examine what they say. Heviu lo ketubat iman, umaseh shekatuben lichshetikansi lachupa have li liintu velo asu benehem mamzerim. It said in the ketubah, now usually ketubah's document is only financial, but he's interpreting it also as a condition of the kiddushin. And in the ketubah, it says, when you bring me under the chuppah, meaning when we do nisuin, then I will be your wife. Now, a simple reading is that, now I'm mikudeshet, and then eventually when you do chuppah, then I'll be your full wife fully. But Hillel interpreted it in a more exacting way, and he understood it as, when we come into a chuppah, then I will have agreed to be your wife, even for kiddushin. But if you never bring me into the chuppah, then I refuse. I never would have did agree to be your wife for the purpose of kiddushin either. In other words, we're interpreting it as a kiddushin on condition that I'll accept this kiddushin on condition that it comes together, it ends with chuppah. But in these cases, since these wives were stolen away before chuppah, so therefore there never was a kiddushin, and therefore they are single. And so when they have the children with these other thugs, those children are not mamzerim. So you see how Hillel saved the day, and this is like a real derasha that's against the opposite of the peshat, but he was able to do this because we are Doresh Lashon Hedyot. Amazing story. Next, Rabbi Yoshua ben Korcha haya Doresh Lashon Hedyot. Detanya, Rabbi Yoshua ben Korcha omer, Hamavet chavero lo yemashkenenu yoter mechovo. Shekach kotev lo, tashlumta di'it lach alai kol kobel dichi. Rabbi Yoshua ben Korcha also would interpret regular language as legal language and make a derasha, as we says in the Baraita, that he said, someone who lends money to someone else. So let's say he lends out $100 and he takes collateral. Let's say the collateral is a Rolex watch that's worth $1,000. Do not do that. You should not take a collateral that's worth more than the original loan. Why? Because in a loan document, we typically write that the payment that you have to give to me corresponds to the value of this item. So since you write that in the contract, it should be true. And don't write more, don't give a collateral that's more than the actual amount of the loan. And it will actually have negative legal consequences if you do. Now, we explain. Ta'ama dichtab lahachi, ha'i la ketab lahachi la kanya. Now we ask, wait, the only reason that he gets this collateral, he acquires the watch, is because you wrote this in the document? What if you didn't write a document? Then the lender would not acquire it? We see that that's not true. If someone took a collateral, sometimes the lender keeps the collateral. In that case, yeah, he has it, and if the other guy doesn't pay, he'll keep it. And that'll be a problem if it's worth more. But sometimes the lender gives it back. He says he takes the collateral, like let's say it's pajamas, and the guy needs it. So he takes it and gives it back. Even though he gave it back, still it's as if the lender owns it. For what purpose would that make an effect? If the borrower died. Generally, if a borrower dies, the creditors, the lender, can only collect from land, but not from movable items, and so therefore would not be able to get those pajamas or that Rolex watch. However, in this case, the halacha is, Rabbi Yochanan taught, he can take it because it's not like he is collecting a debt, but rather it's his. He acquires it. Once he takes it, even if he gives it back, he owns it already, and that's true even if you don't write it in that language in the ketubah. So then why do you write language in the loan document? So what does writing this language help anyone? What does it change? And the answer is, ahane ketiba legeraon. It will help in the case where that Rolex watch depreciates. I know Rolex never depreciates, but let's say it would. And it goes down and it's only worth $50. And so now the lender says, okay, this thing's only worth $50. And so now, give me, you have to pay more out of pocket to make up the difference because you wrote in the document that these are equal amounts. Some interpret that the opposite way, that even if it goes down in value, he can't ask for more because he wrote it's equal amounts. Okay, the point is that this language is binding. And therefore, once you write the language, if the Rolex is worth $1,000, then the lender will say, "Oh, this I have the Rolex. I'm keeping it because look, it says in the document that this is equal to the amount that you owe me, and therefore I'm going to keep it." If you do that, so therefore, it's best to make sure that the collateral is not worth more than the original loan. Okay, next. Rabbi Yosef haya doresh lashon hejot. Tanya. Rabbi Yosef omer, makom shenagu lasot ketubah milveh gove milveh, lichpol gove mechesa. Very interesting. Rabbi Yosef also interprets regular language as legal language and binding, as it says Rabbi Yosef taught. In a place where they make the amount in the ketubah like a loan, then she can collect it as a loan. This is referring to, let's say, she brings in property into the marriage as that she owned or part of the dowry that her father brings, and so let's say it's worth $1,000, so she can hold on to the item itself and say, okay, I want the item back at the end, or it can be evaluated and made into a monetary amount, and thereby she collects that amount no matter what happens to the original property. So in a place where that's the custom is to take whatever she brings in and put a dollar amount on it and write that in the ketubah, and then at the end of the marriage, let's say they get divorced, then he'll have to pay that amount, and no matter whether that property went up or down or is not here anymore. And that would be the exact exact same amount, whatever is written there, he has to pay. Now, there are some places where they have an interesting custom to double the amount that she actually brought into the marriage. So let's say her father says, I want to give you guys $100 to start off your marriage. They would write in the ketubah 200 to inflate the number so that it would look more honorable, right? Oh, look at this nice wedding. Look, he brought 200 in. But everybody knows that everyone doubles the numbers. And therefore, when they get divorced, he only actually, even though the ketubah says, oh, you brought in 200, he really only has to pay 100. Nehar Belai gavu tilta. The people of Nehar Bela, they would multiply it by 3 times to really make it look, oh wow, look how important these people are, that the ketubah is 300, but everybody knows it's only 100, and therefore he only has to pay 100. Moremor, magbe name shevacha. Moremor, he made people collect even the added value. If it says 300, you have to collect 300. So we ask why. Why do you do that? We just learned that if you're in a place where the custom is to put double, then you can only collect half of it. So why are you collecting the increased amount, the exaggerated amount? The answer is la kashya de kane mine ha de la kane mine. It depends whether they make a formal transaction over it. If in that case they made a formal transaction, that means the son-in-law and the father-in-law, this is okay, the father-in-law says, I'm going to put 200 into this marriage, and they do a formal transaction, they do some kind of kinyan with a handkerchief or however they make it. If they did that, that means literally 200, then he has to pay the 200. But if they did not make a formal transaction, then that means they just wrote 200 because that's the custom, but really he only gave 100, and therefore the husband only has to pay 100. Ravina mishabach v'kateb librate. Amru le nikne mine demor. Amru le imikna lamichpal. Imichpal lamikna. Ravina, he did the same thing as was the custom in his place, and he wrote the enhancement, an extra amount for the dowry of his daughter. I think he wrote 200 even though he only gave 100, which is legitimate. Everybody did that. And then the son-in-law said, let's do a kinyan. And the Ravina, the father-in-law, says, no, listen, if you're going to want to do a kinyan, then I'm not doubling it. Then I'm only going to write 100. And if you want to double it and write 200, I'm not making a kinyan. One way or the other, I'm only paying 100. And so you can choose if you want it written as 200 or you want to make a kinyan. Hahu gabrad amar lehu habu la arba me'azuze librati bichtubata she'elach Rav Acha bered Rav Avia lekamed Rav Asher arba me'a di'inun temanya me'a or arba me'a zuze di'inun matan. He had a person on his deathbed whose daughter was getting married, and he said, give her to my daughter 400 zuz for her ketubah, and then he died. Okay, so now we don't know what he meant. So they asked that Rav Acha, the son of Rav Avia, asked the question to Rav Asher. And the question is, when he said 400, did he mean give her 400 and write 800? Or did he mean give her 200 and write 400? Was 400 the amount that you're actually supposed to give, or 400 the amount that you're supposed to write? Good question. Amar Rav Asher hazinan. Amar havula arba me'azuze di'inun temane. Amar havula arba me'azuze di'inun temane me'a. Amar ketovula arba me'azuze di'inun matan. He said, look at the language precisely. If he said, give her 400, that means give her actual 400 and write down 800. If he said write down 400, then that means write down 400 but only give 200. And here, if we look back at the language, he actually said give her, and so that would mean that you give the 400 and write 800. That's one answer, version. Another version of his answer, Amar Rav Asher chazenan. Yamar lichtubata arba me'azuze dinun temane me'a. V'yamar bichtubata arba me'azuze dinun matan. If he said 400 for her ketubah, well then that means he wants to put 400 for a payment that will be given over as part of the ketubah. So that means give 400 and write 800. But if he says 400 in the ketubah, that means and therefore that would mean that he wants it to be written in the ketubah as 400, but he only wants to give 200. Let's see what language he said. He said bich tuvata. So according to this answer, see, he wants it 400 written, but only 200 to be given. Okay, so there's two versions, but in any case, we're going to reject both. Velahi lashana damar lichtubata, lashana damar bichtubata, or at least we're rejecting the second one. And it doesn't matter if you write lichtubat, if he said for her contract or in her contract. Arba me'az dinun matan ad amar havu la setama. It really doesn't matter which language you say. If he says the word ketubah at all, then he means that's what's going to be written 400, which is actually only giving 200. But if he doesn't mention the ketubah at all, he just says give it to her, then that means 400. He should just give it, and he didn't say anything about the ketubah. And in this case, he said havu, but he also said bichtuvata, and therefore that would mean, since he mentioned ketubah, that would mean the lesser amount. Hahu gavra de kibel ar'a mechavre amar imo bar nala yahib nalach alfa zuzeh. A story about someone who took a piece of land as a sharecropper from his friend, and he said, if I leave it fallow and if I don't work it, I'll give you 1,000 zuz, a huge amount. So he worked 2/3 of it, but he let 1/3 of it lie fallow. So now what should we do? So the judges in the Harde'ah, Amar Nehade'eh, Dinahu dehible tilat me'a utlatin utlata vetilta. It makes sense that he should have to pay 1/3 of 1,000, 333 and 1/3, because he left that much fallow. Rava Amar asmachtahi vasmachta la kanya. But the case came to Rava and he said, no, this is called asmachta, which is when you make a commitment, but you don't really mean it. It's like saying a bet or an exaggeration. Like you say, if I come late to your meeting, I'll give you $1 million. I come late. I didn't really mean that I'm going to give $1 million. Everybody knows that. It's not considered real serious language that the person really committed to. So when he said, I'll give you $1,000 if I leave it fallow, he didn't really mean it. Therefore, he doesn't have to pay and any amount. Or maybe has to pay something, but certainly doesn't have to pay the 333. Now, according to Rava, where he says this is asmachta, how come he says this is asmachta, you don't have to pay? How is it different from our Mishnah, where it also says, if he agrees, if I leave it fallow and don't work it, then I will pay the best quality fruit. And there he really has to pay. And the answer is, there he's not exaggerating. This makes sense. Everybody would say, you let it lie fallow? Okay, we're going to make an assessment how much it would, and you have to pay. And pay with good quality, because probably the farm would have produced good quality. So if you're not exaggerating, then it makes sense. If I say, if I'm late, then you can charge me. If I'm late to our appointment, you can charge me $20. Okay, that makes sense, right? $20 of your time because you came late, right, from the doctor's appointment. That makes sense. But $1 million, it's exaggerating, so he doesn't mean it. So here, in the case of the 1,000 zuz, since it's so much more, that we know that's just an exaggeration, and he obviously did not mean to actually pay that amount.
ההוא גברא דקבל ארעה לשום שמה, זרעה חיטה, עבדה חיטה, כשום שמה. סבר רב כהנא לממר, מנקה לכחשה דארעה. Someone received as a sharecropper land to plant sesame in it. Now, sesame has high yield, you get a lot of profit, but it does weaken the land a lot. Now, this sharecropper, he went against the agreement, and he planted wheat instead. But luckily enough, the wheat was so good that it yielded a profit that would have been the same as that for sesame. So Rav Kahana was thinking that the owner has to deduct from the amount that he is taking, because now he got an unexpected, although he didn't ask for it, he does get this benefit that his land was weakened less.
So maybe the sharecropper can pay him less than they had decided at first, right? Because they're getting the same profit, and yet his land is not getting weakened as much. That's what he was thinking. Amar Rav Asher Rav Kahana Amri Inashe Kahasha Ar'a Vela Lichosh Mara. But Rav Asher said, no, I don't agree with that, because there's a folk saying that says, let the land be weakened and let not the owner be weakened. In other words, a landowner would rather take the profit up front and worry about the weakening land next year, and therefore he wants all the profit. Hahu gabra de kabil ar'a l'shum shemeh zar'achite abdachite tefe min shum shemeh sabar Ravina de memaria hible shebacha de bene bene. A similar case of a person who received land as a sharecropper to plant sesame seeds, and instead he didn't listen and he put wheat. But this time, the wheat actually yielded more than sesame would have yielded. It was like really good wheat, and a lot of it. So Ravina was thinking, let the benefit, the added profit, the difference between what sesame would have been and what this wheat actually was, that added amount, let the sharecropper keep the entire amount. But Ravacha Midifti is told Ravina, what, did the sharecropper only, he's totally responsible for that extra amount? Did the land not contribute also to getting this enhanced wheat that ended up being more valuable than sesame? Obviously, it's the owner as well, and therefore the owner also deserves his share of that added unexpected profit. Amri nehar de'ai. Hai iska palga milve ufalga pikadon. Abu Rabanan milita denichale lanove venichale lamave. Okay, this is a law of interest back to ezehu neshech. One of the loopholes to get around charging interest. If you do have someone that has a business and he wants to borrow money from an investor and is going to get back more, so you have to structure it not as a loan, but rather something called iska, in which we say, let's say there's he's going to lend out $100. It could be money or it could be goods. So we'll structure it that 50, half of it will be a loan and half will be a deposit. The half that's a loan, that means that here, I'm giving you 50, you have to give me back 50. And no matter what you do with it, you have to pay back the same amount. So if you make a profit, you keep the profit. If there's a loss, then you suffer the loss. That's the milveh. Whereas the pikadon, I'm giving you a deposit to work for me, right? So, and go and take this deposit, and then whatever money you make, you give to me. That's my profit. And if you lose, then my loss. And that way, we're both splitting the gain and the loss. But we're doing it by splitting the investment or loan into two different parts. Okay, that's the way it'll work. Now, the rabbis actually did add another piece to this, because this still has an aspect of charging interest, because you are managing my money for me for free, right? If I'm giving you $50 for a pikadon and go do business with this, and now I'm getting benefit from you working for me and I'm not paying you. And therefore, we have to do something to fix that, which would mean either that the borrower, worker, has to get a little bit more of the profit, or the lender has to accept a little bit more of the loss. And so that's how they would structure it in one of those ways. And so then the Hadadah said that the rabbis made a venture here that's good for the borrower and good for the lender, right? Everybody will benefit. I mean, if it goes up, then it's good for both parties. Now, Hashtad Amrinan Palga Milve So now that we understand how this iska works, and half of it is a loan, so if the borrower wants to take that half, that $50, and instead of investing it and buying and selling, he wants to go buy beer and just drink it away, he can, because it's his money to do with it as he likes, like any loan. So is that true? Rava amar lahachikadu le'iska damale ki ahibna lach li'asuke be velan mishte beshichra. Rava says no. We call it an iska, even though we're structuring it as if It's a loan, but still it is called a business venture, and therefore the lender can say, I didn't give this to you to drink it away as alcohol. I gave it to you to work with, and having a bigger amount of capital is better. And so if you're going to drink away your half, and then my half is not going to do so well either, I want you to take all the money and work hard to go out and make money for the both of us. Amar Rav Idi bar Avin, v'im met na'aseh metaltelin etzel banav. Rav Amar lachi kadu le'iska di'im met lo ya'aseh metaltelin etzel banav. So Rav Idi bar Avin says that since half of it's a loan, and let's say it's goods, let's say the lender gives $100 worth of clothing. Here, go take this and go and sell it. Now, if the borrower dies, so where does that clothing go? It's going to go to the heirs. So this opinion says this is movable property because it's a loan, and if the lender wants to come and collect it, he cannot collect movable property. That's the rule that we already saw. You don't collect movable property from orphans, and therefore he cannot take that clothing back because it's a loan. Rava, however, says, no, we call it a business venture, and therefore, if the borrower dies, then it's not considered movable property that belongs to the heirs now, but rather he can come and collect it because it was part of their joint venture. So Rava says, even though it is structured as a loan, but it still retains the aspects of being a joint partnership, and therefore you can go and take it. Amar Rava, Chada iska utre shetare peseda de malve. Rava says that if you have one business venture, but you split it up into two contracts. So let's say it's $100 worth of whatever, but there's two lots of clothing, lot 1 and lot 2. And I split it, we write two documents on each of them. And each document will be half loan and half a deposit. And so this, if you structure in that way, it'll be to the detriment of the lender. How so? See, if you write one document on the entire $100, and remember, the lender will accept a little bit more of the loss in order so that it won't be interest. So let's say with the lot 1, he makes $10 off of it. Lot 2, he loses $10. Now, if you put them all together in one document, okay, they broke out even. So then there's no profit or loss. However, if you make it two different documents, then there's $10 of profit and $10 of loss, but they don't cancel each other out. Instead, the lender will take some share, let's say half of the profit, but less than he'll have to accept more than half of the loss, because that's the way it's structured, and they'll end up losing more money by making it two separate documents rather than one. The other way is also true. Today's ke v'chad shetara peseda Delove. If you have two ventures, let's say they agreed, they went and he gave him some money today and some money tomorrow for two different ventures, but they write one contract for it, and then that will be to the detriment of the borrower. Again, because let's say the same thing, one of them goes up $10 and one of them is loss of $10. So if you wrote it all in, if you write it all in one, then they cancel each other out, and now the borrower will get nothing and lose nothing. But if you write it as two separate documents, then they'll split the profits and evenly, and the loss, the borrower will take a little bit less of the loss, right? Because that's how these things are structured, and so that'll end up being for the detriment of the borrower. V'amarava, hayman dekabel iska, amin chavre ufsed, terachu malie vela odae. Lama se amar le dari mehaach peseda behadai, mishum da amar le lachi tarachta le malyute ki hechi dela likru lach umafsid iske. Rava says, let's say someone enters into an iska, so he takes some $100 from the person, and he loses money during the process. Now he could stop right there and come back and say, listen, I lost half the money, and so you take more of the loss, I'll take the rest of the loss. But this guy didn't do that. Instead, he went and worked extra hard, and he was able to replace the loss. He did it somehow, maybe from a different venture, or he got some other money. He was able to turn a profit. He cannot go to the lender and say, you should cover that loss, because I could have stopped in the middle, and then you would have had to cover that loss. So you should cover that loss now, even though I worked extra hard, but that's for myself. They cannot do that because the lender can tell him, I know why you worked extra hard, so to save your reputation, so that you would not be called a loser in business, and then nobody would want to do business with you again. That's why you didn't come and tell me, and you worked hard. It's great that you did that, right? Chazak u'baruch, but you did that for your own sake, not so that I would reimburse you. If you really wanted, to stop the venture there, then you would have done so, and then you would have gotten this negative reputation. So since you worked hard, and it's good that you did, but you did it for your reputation, and you did not make a claim, so therefore I do not share in the loss. V'amar Rava, hane be'teret avdei iska behadeh ve'ravach, v'amar le'chad lechavre ta liflog. I amar le'idach narvach tefeh, Dinahu de me'akev. Vi amar le habli palga de Ravcha, amar le Ravcha le karna mishtabed. Rava says, if you have two people who are partners in a business venture, and they made some money, let's say they agreed to be partners, they're going to do this until a certain date, they're going to work together for 1 year. But now they made some money after a couple of months, and one of them tells his friend, let's split, right? Let's dissolve the company, we made some money, and let's stop now. The other one can refuse and say, no, I want to continue because we're going to roll. I want to make more money. And he has a right to prevent the other guy from taking his money out of the deal. And if the guy who wants to get out of the deal says, okay, fine, leave the principal, but give me the profit, right? Give me half the profit that we made, and you can still use the principal. So the other guy can say, no, the profit is lien to the principal. It's all one, and I want to leave the money in the business and not take it out so that we can grow it and make more money. That he has a right to do that. That was the original agreement. So now he said that, you said that the profit is linked to the principal. So now the guy who wants out says, okay, give me half the profit and half the principal, so because they're linked together. He could say, no, no, the joint venture is linked to both of us, right? We're joined in. And if I only have half the amount to work with, I won't be able to do as much as if I have your share also. That was the agreement. And so he doesn't have to let him out. And if the guy who wants out says, give me half the profit and half the principal, and listen, if you suffer a loss, I will suffer the loss alongside you. I'll pay for half the loss, but I just want to cash out now, and I'll guarantee you half the loss. So isn't that good enough? And the other guy can still say no, because the luck of two people working together is better. It's not just luck, it's also having more capital means that you have more possibilities, and therefore you can say, nope, you have to leave your money in, and they have to work together until the end of their agreed term. Baruch Adonai Le'olam. Amen v'amen.